All right. So, Mr. Kaehne, I found you. I'm going to kind of do this after the introduction here. Is I Googled cannabis lawyers in Wisconsin, and you're the top one that popped up. So, according to Google, I'm going to call you the top cannabis lawyer in Wisconsin. How do you feel about that?
Well, I think there are a lot of attorneys in this state that are, fighting for legalization. Certainly, some are more involved than others. I like to think that I'm one of the few that's willing to put his reputation professionally out there and say that I believe very firmly that legalization should happen medicinally and recreationally. So to be lumped in the category with those other attorneys is quite honestly a privilege.
It is. It's actually on when you reach back to me so fast. I really appreciate that, and thanks a lot for doing that. So I'm going to dive right into our questions. We got about 7 questions here. First question I'm going to ask you is, what can you tell us about the cannabis laws in Wisconsin?
Okay, so generally in Wisconsin, obviously we don't have the legalization medicinally or recreationally. So what you're looking at in terms of your first possession, if you were to be arrested by police, that could range. It could be an ordinance, which is a civil forfeiture where you are not facing a criminal conviction. You're not facing probation, jail, or any of those other stigmas and ramifications that would come along with an actual criminal offense. It could be a misdemeanor charge. It could also, in some circumstances, simple possession could turn into a felony in Wisconsin, and here's how. It could be a possession with intent to deliver charge, and we see that quite frequently. And this is all a charging decision, an arrest decision, I should say, by law enforcement. When law enforcement arrests someone, how the process works is they make an arrest decision, but the police don't have the authority to make a charging decision. So the arrest and the police reports, the body cams, all the evidence they have will then get forwarded to a district attorney's office, and they will ultimately make a charging decision. One thing I'd like people to know about possession with intent to deliver, it's simply based on a variety of factors, right? So you could be pulled over in your car, have an ounce of marijuana in a backpack, and they find a scale in there, perhaps a drug ledger, or a significant amount of cash. That in and of itself can be a felony charge, possession with intent to deliver.
Because everything's in with it, it's in a backpack and it's got a scale with it, right?
Exactly, Craig. And I had a case about 3 or 4 years ago where the prosecutor actually charged my client out with possession with intent to deliver. It was an ounce of cannabis in a large baggie, but then broken down in 4 separate baggies as quarter ounces of marijuana. The prosecutor believed that he could prove, just based on 4 separate baggies, that each baggie was for distribution. Obviously, that's an absurd statement and position to make, but we litigated that right up until trial, and ultimately the prosecutor backed down. But I use that as an example because in that situation, there was no scale, no large quantity of money, nothing to suggest my client was going to deliver this.
So question number 2, I'm going to ask you, we talked about this earlier, and I think this is a very good question. My friend Ron brought this up. What are 1 or 2 laws that you wish everyone knew about when it comes to cannabis in the state of Wisconsin?
Okay, good question. And the first issue I'll address is that anyone that has a prior Chapter 961 conviction, Chapter 961 is a Wisconsin statute that covers possession of cannabis, heroin, narcotic drugs. It also covers possession of drug paraphernalia. So anyone in our state, no matter how dated that Chapter 961 prior is, if they are arrested on a second offense, that is a felony. And again, prosecutors have discretion how they charge it out, but typically what prosecutors will do in our state, charge as high as they can, and maybe amend down through plea negotiations, but they'll charge it out as a felony. So
your second offense, if you got caught 10 years prior, if you got caught 10 years later with a gram or 2 grams or paraphernalia of any sort, you could be charged with a felony. That's what you're saying.
Exactly. And I think the majority of people don't understand that. You could be 18 years old and you are convicted of a misdemeanor possession of drug paraphernalia for a pot pint. And 15, 20 years later, you're pulled over, you're searched for whatever reason, they find a bud of marijuana on your person. That would be a felony offense. That is a Class H felony in Wisconsin, facing a maximum penalty of 3.5 years in prison, a $10,000 fine, and on top of all that, the court can suspend driver's license from 6 months to 5 years, regardless of the quantity.
And prosecutors will start there, and sometimes they stay there, right? And they won't come down from there.
That's right. You know, a lot of my clients think, hey, Brett, you know, if we keep pushing this towards trial, we'll get better offers, better offers, better offers. And sometimes that is true, but when these prosecutors dig their heels in and they think they have probable cause for the charge, that's why it's charged out in the first place, but also think they can prove this case beyond a reasonable doubt to a jury, they'll stick to your gun.
That's horrible. We live in a time, it's like a wild, wild west up here. It feels like we're in an island up here, Minnesota and Wisconsin, when it comes to cannabis reform or laws or anything like that. Can someone get charged for driving under the influence of marijuana in Wisconsin? I think this is one that everyone talks about, and this is what I would like to hear from you.
Yes, the answer is absolutely 100% yes, and it factors in two different ways, Craig. First is if they can prove that you are under the influence of cannabis, that you cannot safely operate a motor vehicle, that would be operating while under the influence. The same as a drunk driving, same as an OWI. So that's category one. Category two, which is very frightening, and I'd like to educate listeners on to your podcast, is the fact that we are a zero tolerance state in Wisconsin, which means if they detect any amount of Delta-9 THC in your blood, that is enough to convict you. So meaning they don't have to, as the prosecution, prove any type of impairment.
At the time
of operation, correct.
So what you're saying is if you smoked marijuana 3 days prior, it's in your system, there's no way of them telling the difference from there to now. Right.
And that's problematic because the whole law is to protect people on our public roadways from someone that's impaired, right? Same as drunk driving. The federal government has done studies that show heavy smokers, that people that smoke cannabis on a daily basis. They did a controlled study and they weaned people off for between 24 and 48 hours. They did blood draws before they weaned them off cannabis and then after. 24 to 48 hours after using cannabis, these heavy users still had Delta-9 in their system. Now, were those people a danger on the roadways? Absolutely not. And you look at Colorado as always the test study because they've been dealing with these issues the longest. Colorado's doing it, the right way. They have a limit. So for the blood alcohol concentration in Wisconsin, they have to prove a 0.08% or higher blood alcohol concentration of ethanol. What Colorado says is, well, you have to have 5 nanograms or higher of Delta-9 in your system.
You said nanograms?
Correct.
Okay, sorry about that. Yep.
Yeah. So that's at least the standard that, in my opinion, is justifiable. But saying that someone is operating on the roadway and has Delta-9 in their system, I say, so what? I think it should strictly be on impairment because that's the danger to the public.
So in a quick synopsis here, what you're saying, now I'm glad you brought that up about Colorado being the Tesla because they are now the whole California and everyone else is coming up with it too. But I've had friends and colleagues say, well, how do I know? Like I have a friend who owns a business and they deliver. I'm not going to say names or anything, but how does as a delivery driver, how would I know if my workers are impaired? Now I can say Colorado has a system set up for they can test your nanograms and your blood content, which would determine how much THC is in your blood at that time. So there are ways to detect that at the time. We just need to utilize that.
Absolutely, and we just have to have the laws in our state conform to reality. And sometimes that's difficult. And it all is based on education, educating our legislators, educating people in government on the risks and what's a dangerous situation, what's not. And we already have the tools in place to make those determinations.
Talked about this one earlier on the phone, and I'm going to kind of sneak this one into here. Police, like, so when you get pulled over and let's say you have hemp on you, I'm going to show what a bag of hemp is, if you don't mind. Got a pound of hemp right here. You can't see it with my green screen, but if you had, let's say, an eighth of that and it's actually hemp and you got pulled over from a police officer, their test kits are out of date. If you ask me, they're not in compliance, right, with current state statutes. Technically under state statutes, you possess hemp with no more than 0.3% THC. That's like, I don't know if it's state statute, but that's the law, right? 0.3%. So a police officer's test kit only tests 0%, nothing. So anything above 0. So there's that 0 to 0.3 where there is you can get this could be marijuana in their eyes, right? Have you ever had situations like that before?
Absolutely, I have. And I've talked to people throughout the system what a major problem this is. So when police test a substance, they have what we call field tests. And there's the narco 2-pouch test, there's a Ducanoy-Levine test. All that really means is it's a clear plastic baggie with a clear liquid inside. And
Yep.
they drop a portion of the substance in. So if it's a green leafy substance that they think is cannabis, they put it in the baggie, they shake it up, and if it turns purple, that's presumptively positive for tetrahydrocannabinol. The problem is,
I like how you said that tetrahydrocannabinol. Yep. Only a few of us can say that. All right. Sorry.
no problem. And the issue is that if you have flower CBD, as you just showed us, they can't distinguish the difference between that and actual cannabis with THC in it to a higher quantity. So people are getting arrested. And I shared with you the story. It was actually in Disneyland. I looked it up.
Disneyland.
There was a grandmother who had her CBD vape pen. She had, I believe, arthritis. You know, she was an older woman in her 70s or 80s. And this pen was found on her by security. Law enforcement came, tested it. It tested positive for THC. That woman spent the night in jail for possessing CBD because of the presumptive test and the error in the test.
A grandmother.
A grandmother there with her family at Disneyland.
Oh my gosh. It's crazy. Each state you go to, they're different laws and everything. And I just make it one umbrella law, legalize it and go with it. It's my opinion.
And so if I could piggyback onto that. So just as part of how that relates to the system, Craig, how I handle this is over the years, I've created a brief that I file with the circuit courts. And what it does is I move to exclude that field test from being introduced at trial because of its inherent unreliability. What that does is causes the district attorney's office to send this green leafy substance to the state crime lab. We have 3, Milwaukee, Madison, and Wausau. And they have to do formal testing on the substance and prove to me it's THC. I've had some tests come back as inconclusive. And a client told me once, Brett, I got high the night before, like it's weed. Well, let me do my job, make them prove it. And it comes back inconclusive and the case is dismissed. But what that relates to for the listeners is imagine the amount of money in taxpayer dollars we are spending to send a gram, 2 grams, 3 grams down to the state crime lab. You have physically an officer drive it down, it's tested in the laboratory, and then comes back. Is that really a useful source of our taxpayer dollars? I don't think so.
No, and it's probably a hard one to measure the exact number because there's so many different people touching it, moving around, the gas to get there, the hourly wage, the benefits. I mean, it's just why all over cannabis, something that's grown in earth. Have you seen a shift in the stigma of THC when it comes to enforcement?
Yes and no. And here's why I say that. Here's why I say that. It's dependent on the county. So if you look at, say, Milwaukee County, Dane County, which are more obviously liberal leaning, liberal values, and I'm not going to get too far into politics on here. It really does, politics does shape how people view cannabis. So I know they just decriminalized within the city of Madison. What does that mean? You can have a certain amount so long as you have no priors, and they'll ordinance it out. It's not going to be a criminal charge. It's not that they let you just walk around smoking weed, but they're taking a different view. Where, for example, you have Ozaukee County, which is just south of the county I'm in, Sheboygan County, ultra conservative. They're going to look at things a lot differently. Another great example is Calumet County. I practiced quite a bit in that county. The district attorney of that county told me to my face in court that he does not believe in ordinances for THC possession. What do you mean you don't believe in that? We've got, 20-some-year-old kid was cooperative with police, and we're talking about 2 grams of weed. We can't just do an ordinance and we have to strap this person with a criminal conviction. So it really depends on law enforcement. How are they going to view it, first of all? But ultimately, again, they make an arresting decision. And if they refer these charges to the DA's office, that prosecutor has all the power in the world to decide how they're going to handle it. So it's really, Craig, county by county dependent.
And what people need to realize too is those district attorneys are voted in. So think about that during election times. If you're in an area where your DA is very conservative leaning on these charges, Think about that, and you brought up a good point. There's a difference between criminally charged and ordinance. Ordinance is more like a speeding ticket, right? Your city ordinance, and criminally charged is when it's on your record, and you're going to the district attorney's office. And you brought up a good point. I represent the 8th district here in the city of Superior, and I'm probably wrong here, but about 3 years ago, I pushed to decriminalize marijuana in small amounts. I tried it for 28 grams because that's an ounce. Came back they came back with 25. Whatever. I don't understand 25 grams because it's just their way of someone having an ounce and saying, oh, you're above that threshold because an ounce is 28 grams. It's that kind of stuff that needs to change. And I think city by city and hopefully county by county, they're going to go through this process of decriminalizing and sending that strong message to Madison that we don't care about the flower anymore. Focus on the real violent crimes rather than the cannabis consumption.
Absolutely.
Next question here for you, Brett. How are judges and prosecutors treating marijuana offenses that you see? I know we kind of talked about it a little bit, but if you can dive into more depth on that one.
Sure. So, with judges, for example, in Sheboygan County, we have 5 circuit court branches. So we have 5 different active full-time circuit court judges. And I can tell you just in this county, you can see a different flavor and feel of who believes in what, in arguments that you should maybe make in front of one judge that would not fly with another. Craig, when we're speaking about these topics, a quote popped in my head immediately that a circuit court judge, I will keep the county anonymous, but the judge said something to the effect at sentencing that it's a federally regulated, a Schedule I narcotic, right? A Schedule I drug. That's what cannabis is labeled federally.
That's marijuana. Yep.
Yeah, marijuana. And cocaine is a Schedule II narcotic.
What? So Schedule I is marijuana and Schedule II is cocaine.
Right. So Schedule I is heroin and marijuana is in that same, but Schedule II is cocaine because cocaine does have some medicinal value. That's why it's a Schedule II.
Like Novocaine.
I mean, back in the day, right? Coca-Cola, when it was invented, there was cocaine being used medicinally.
I just can't believe that cocaine ranks less of a drug if you're going to go in a ranking system than marijuana.
And this judge, so this was a case, and my client has given me permission to share. I will not use his name, obviously, but he was a 22-year-old young man, and he was out joyriding, smoking with some friends. They got pulled over for a traffic violation. The deputy then smells the odor of marijuana and says, "Hey, who's got weed in here?" My client was in the back seat. He handed over his pipe. He handed over, I believe it was 3.2 grams of cannabis. So he was arrested and criminally charged with misdemeanor possession of THC and misdemeanor possession of drug paraphernalia. And ultimately, we ended up resolving the case in court. And I made the argument, I got to know this young man, and I like to really personalize myself and get to know my clients personally, because then I can be a better advocate for them in court. But this young man had so many debilitating diseases that we were able to document through medical records, fibromyalgia, things that were very painful. This young man self-medicated with cannabis. He went from 22 prescription medications down to 3. And because of that, he was then also able to get off disability, Social Security disability, and work a full-time factory job. And this is the argument I presented to the court. And this is when the Schedule I came up. Well, Mr. Kaehne, this marijuana is the same as heroin because the federal government says so. And my mind almost exploded in the courtroom because that is such an ignorant statement to make, scheduling aside. But what I was also met with this particular judge is he said that medicinal marijuana is a farce. And
is a farce.
Is a farce. And I had in my briefcase, I had lists of studies that our own federal government is saying, here is what cannabis can treat and help. Of course, the judge wasn't interested, but I share this with the listeners, Craig, because this happened 2 years ago. I mean, this is 2019. This sounds like something a judge would say back during Reefer Madness, but that's alive and well in our court system, unfortunately.
That makes me go crazy just thinking about that. And I can't imagine how you felt in the courtroom when listening to that judge. If you're going to use the word farce, I mean, that determines how old the judge can be, I guess. Will Wisconsin ever legalize, in your opinion?
100% yes. It's a matter of when, not if, in my opinion. And as a law school professor told me, the answer to every question, unfortunately, is money. And, you know, as I grow older and go through the process of the criminal system, it holds true. So why do I say that when it comes to legalization? I just did some research last night, and Illinois, the state of Illinois, from January 1st of 2020 through October of 2020, netted $100 million in tax revenue just on cannabis sales. $100 million.
I wonder how much came from Wisconsin.
That's a great point. And that's where the government's going to come in. I mean, look at Colorado. Their school system is better than it has ever been. Their public roadways and bridges are getting repaired. All the things that our tax dollars go to. That's why I say yes, it's going to happen. Now, in my opinion, we're very conservative when it comes to making any changes. But we look at the states around us. We look at Michigan. We look at Illinois. I think Minnesota, that domino is going to drop soon. I think Wisconsin's first going to go medicinally, because how do you make the argument against it? And Marquette did a poll last year where it's something crazy, like 78% of the citizens of the state believe medicinal marijuana should be legalized in Wisconsin. So we have the numbers, we just don't have the right people in government enforcing what the people want.
Yeah, that drives me nuts, because 75% support it, but they keep electing the officials that are against it. So it's our own fault in the sense, our voting base, that this isn't happening, in my opinion. But if you are an elected official, I hope that someday someone has a change of heart and understands what they're missing, what our state's missing out on, and what people are missing out on when it comes to legalization.
Right. And Craig, you know, one thing I always think about too is, you know, you can go on YouTube, we're in the internet world, anything you want to learn about, of course, with the right source, you can find out about. But, you know, I watch these videos, for example, of these young kids having seizures, and they take THC in various forms, liquid, they put it in their mouth, and this kid is a happy, normal kid playing. Who are you as politicians to say that that child should not be able to take that medicine? This is not just an issue for all of us citizens. It's really a bigger issue. It's a quality of life issue. And that's what really makes me passionate about changing these laws. So again, I think medicinal is going to be our first domino to fall, and recreational is going to happen. It's just a matter of when.
Right. And just if city by city and county by county decriminalizes, I mean, at the end of the day, what are we really accomplishing by making it illegal? What are your thoughts on how Wisconsin handles expungement of criminal convictions? This is my favorite question, and this is why I'm saving it for the end here.
So not well enough to answer it bluntly. So Wisconsin statute 973.015, that's what codifies the expungement eligibility in our state. And currently the parameters are too strict, in my opinion. And I know that there's currently a bill that's looking for sponsorship to move forward, where we are trying to amend the expungement laws in our state. And there's 3 points I want to make on expungement in Wisconsin that need to change as soon as possible. The first being that under current law, Craig, you have to be under the age of 25 at the time of commission of the offense in order.
Who comes up with that age? Right. Okay. Yeah.
No, it's the same when prosecutors give me offers. I say, do you have a dartboard in your office and you just throw and hit a number? And you're right. Where does 25 come from? But you know, that's an arbitrary age that we're looking to change through this bill. I shared with you earlier the example of with this pandemic and people being laid off of work. What I am seeing is people in their 50s, 60s that have never had a criminal charge. Let's say they're at home, maybe drinking more than they should, argument with the wife, charged with disorderly conduct. Why can that person not have the same benefit of proving themselves to the court, having that charge wiped out just because of an age limit? So that's number one that needs to be changed, and I hope we're successful in doing that. Number two major issue I have is under the current law, expungement must be ordered at the time of sentencing, or you can never petition for expungement again.
That's horrible.
So it's terrible. So you get to court, you have the sentencing argument, and the judge goes, yeah, well, I gave you a break on the jail time. I'm not going to expunge this. Well, give the individual an opportunity to prove themselves. Say, hey, you can come back in a year, 2 years, 3 years. Show me how you're doing. I want no further law violations. Maybe do some community service, but let's assess down the road if you're eligible for expungement, not today, the time of sentencing. So that's number two that has to change. And number three, and the bill is looking to do this as well, expand the eligibility. Current laws, you're eligible for expungement in certain circumstances on misdemeanors, Class H felonies, and Class I felonies. That needs to be expanded. We don't need to just do lower class felonies. Now, I'm not suggesting something as serious as a homicide or a sexual offense, but there are a lot of different felonies that are higher than a Class H that we should consider expunging from someone's record. And it goes back to rehabilitation. We want these people to be productive members of society, to move forward and learn from their conviction, and not have this ball and chain of a criminal charge following them the rest of their life.
Would you say Wisconsin has the strictest laws when it comes to expungement? And maybe you don't know that answer, but do you think it's maybe you can compare it to our surrounding states?
Yeah, I think I wouldn't say the strictest at all, but I would say we're in most need of some reform and change because our expungement laws have pretty much remained static for decades.
50 years, I would say, back to the 70s, if my numbers serve me correctly. I think that's, maybe I'm wrong, but when you get charged with a crime, I think when you're certain crimes, maybe not, but especially marijuana charges, when you've done your sentence, you've done your time, you've done your probation, at the end of it, you should be able to just move on in life, in my opinion. And there are people who decades down the road still have a hard time with their employment, their housing, young people maybe in their 20s or 30s that are getting into college, wanting to join the military, all these other, and housing. I always say public housing because these records follow them. And if you've done your time, you've served your sentence, you paid your fines, and you've done your service to your community, whatever it is, I feel like you should be able to have that off your record. And like you brought up a good point, right now it can be off your record if it's brought up at the point of sentencing from the district attorney, or that's probably who it would be. And if it's not talked about at that, then you're SOL. I mean, and it's not fair, in my opinion.
Right, I agree with you. And again, it doesn't look into what are our expectations as a society when someone is criminally convicted. We want them to do better, right? And I'm not saying in the sense of possession of marijuana, but any charge really, we don't want them in that situation. We want them to better their lives. And I spend a lot of time with my clients working on that while the case is open. If you want to be eligible for expungement, prove it while the case is open, because the only time we have to convince the judge that it's appropriate is at the day of sentencing. So, that's a heavy thing. We can't come back in time with all these great character letters and, hey, my client got a promotion at his job and he has a family now and is married. None of that matters under current law. And as a society, it should matter.
Yeah. And I wish I had the name. I'm looking at my paperwork here. I wish I had the name of this bill, the number of this bill. That's I think the deadline for it, for looking for sponsorships, coming up the next couple of days. If anyone in Wisconsin is listening to this, reach out to your local, your elected official, your state legislator, and ask them to support this bill, because this is something that's outdated that needs to happen. I don't care which way you lean, left or right. We all make mistakes. And we all deserve a second chance.
Absolutely.
I think that's, when it comes to our questions that we went over, I think that covers what I wanted to talk to you about. And if there's anything else that you want to add, let me know.
Sure. Well, Craig, I think one point that I would like to make is we have so many roadblocks in the way of legalization. And so we need to start educating people about the roadblocks, and we need to start thinking collectively as a community of how do we get around these roadblocks. And obviously we talked about politics. Big pharmaceutical companies, they do not want legalization, and they have the money and the pull, and the politicians' pockets line to make sure it doesn't happen. Why? It's going to cut into their profit. Same in Wisconsin with the Tavern League. The Tavern League and I think that gets overlooked a lot. Right? The Tavern League does not want legalization. Why? Again, looking at Colorado as a test study. Alcohol consumption went down in Colorado once legalization happened. It's down to this day. But what else went down? Drunk driving deaths, accidents, all of the things that come along with alcohol. And again, I'm not trying to knock alcohol too hard, but let's look at these two things and let's look at the roadblocks. The Tavern League does not want legalization because that's going to dip into their profit. And fourth and finally, I'd like to share with the listeners, let's educate not only ourselves, but our loved ones. And here's what I mean by that. I call it the Doritos stigma. Everybody, I shouldn't say everybody, but a lot of people that don't want legalization will say, hey, well, the problem is everybody's going to sit in their basement eating Doritos, getting high, playing video games. That's not true. I know people from all walks of life, doctors, professionals that use cannabis for a variety of reasons. So I'd like to leave the listeners with, from my point of view, let's educate others. Let's talk to our loved ones and family about, hey, when I get done with a stressful day at work, I use cannabis to deal with my anxiety instead of taking these medicines that have these horrible side effects. And I think if we start educating those around us and understanding like, hey, this is more of a bigger topic and a quality of life issue than the stigma of reefer madness, that's where we're really going to make some inroads to getting legalization across the board.
Amen. What did I say earlier? More people have been have overdosed or have been trampled to death by unicorns and they have overdosed on THC.
Which is a fact, Craig.
That's a hard one to say. I've been practicing that one and I still messed it up. Well, I appreciate your time. And if I have down the line, if I have any more questions, I'd like to keep doing this with you and talk about other product or stuff coming down the pipeline with laws and everything else.
Craig, anytime, I'm happy to join you. And again, this podcast that you put together really is a great vehicle for educating others. So anytime I can give any input, I'd be happy to join you.
Brett Kaehne, you can represent anyone in the state of Wisconsin, correct?
Anyone in the state of Wisconsin.
So if you're listening and you have a marijuana charge or anything that you want to fight, I encourage you to reach out to Attorney Brett Kaehne. Where are you located?
I'm located in Sheboygan. I have practiced all over the state. I've had cases in Rhinelander all the way down to Iowa County and everywhere in between. So we're here to help people, and thank you for your kind words.
Legalize it and tax it. Have a good day, buddy.
You too. Thank you.